Hello, I'm Joanne Bone and I work at Irwin Mitchell. I've been a data protection lawyer for over 20 years and today I'm going to talk to you about GDPR. GDPR is a hot topic because it is root and branch reform of data protection. It's also the subject of a lot of misinformation, so we're going to do some GDPR myth busting today as well as look at what's required. So what we're going to look at is what GDPR is, what does it apply to, why you need to be bothered about it, and how best to prepare for it. You'll see from the slides that we have a lot of running imagery involved. That's because we consider that preparation for GDPR is not difficult, but it does take time and effort. So it's a bit like training for a marathon. GDPR compliance is more of a marathon than a sprint, although when we look at the deadline for it being brought in, I'm sure that you'll feel it's a bit more of a sprint than it was a while ago. The first thing we are going to have a look at is the scope of GDPR and where it has come from. It is an EU regulation and it will have direct effect in the UK even though it's come through the EU legislative process. It will replace the Data Protection Act, so anyone that is familiar with the Data Protection Act of 1998, that will go and will be replaced with GDPR.
So John, what about Brexit? If GDPR is a piece of EU legislation, then isn't it right that it won't be applicable in the UK after we leave?
No, that's not going to be the case. The government have accepted that we do need to implement GDPR, and so they are going to enact a new Data Protection Act. So as I said, the 1998 Act will go, but there will be a new Data Protection Act 2018, and that will expressly say that GDPR will take effect in the UK. So GDPR is happening. Anyone that's put their compliance on hold because of Brexit, you need to make sure that you restart very quickly. You'll see that it will come into force on the 25th of May 2018. There is no grace period. We are currently in the grace period, so it will take effect on that date in full. So in order to work out how you need to comply with GDPR, we need to understand a few of the defined terms before we go much further. So what does GDPR apply to? GDPR applies to the collection and use of personal data. Personal data is information relating to a living individual. So this will apply potentially to consumers, to your employees. There is often a misconception that GDPR and data protection doesn't apply in a business-to-business context, but this isn't correct. Both sole traders and partnerships are regarded as individuals from the point of view of GDPR. In addition, if you are contacting individuals within a company, then even though they are in a company and company data isn't caught by data protection rules, the contacts that you have within that company will be caught. So that if you are marketing to people within a corporate environment, you will still have to think about data protection in order to do that. Once we've established what personal data is, then we need to think about, is what you're doing caught by GDPR? GDPR applies to the processing of personal data. Processing is a very broad term. It essentially applies to any use of personal data, so in terms of accessing personal data in terms of to review it or to amend it or potentially even storing it, can be processing. It's a cradle-to-grave definition. I'd strongly advise that what you don't do is try and argue that anything you are doing with personal data falls outside the scope of the definition of processing, because it's very hard to do that. So now we know what personal data is and we know what processing is. So where does that fit in? Well, GDPR applies to processing of personal data by automated means, so by using a computer, and by non-automated means. So what that will mean is that if you have paper data, you are potentially caught by GDPR. The paper data has to be in a file that has sufficient structure for it to be caught, but nonetheless, it does mean that paper data is caught. Now, this isn't anything new, and it has been the case since 1998, when the current Data Protection Act came into force. So hopefully I'm not telling you anything new, but it is worth a refresher because often it is something that's overlooked when we talk to people about data protection compliance.
Joanne, some businesses might have potentially staff members who keep their own lists of names and their own paper files and that kind of thing. Would that generally be covered by GDPR?
I think there is potential for it to be covered, Claire. Yes, absolutely. And businesses need to understand about these sort of hidden or secret databases. We're going to talk about data audit in a minute. And one of the things that should come out as part of this data audit are any sort of unofficial or secret databases. There should be a database amnesty, because a business needs to understand what these paper records are so that it can work out whether or not they are sufficiently structured to be caught by GDPR, and potentially can have a think about whether or not they need to be got rid of, because there are obligations under GDPR for things like data minimisation. The next thing that we need to understand before we look at how best to go about your compliance programme are the different types of personal data. Personal data is categorised under GDPR and in fact under the Data Protection Act that we're currently operating to. And you have both ordinary and special categories of personal data. I'm going to have a look at what falls within the definition of special categories of personal data first, simply because ordinary personal data is everything else. So special categories of personal data, that covers things like trade union membership, political opinion, racial or ethnic origin, health data, genetic data, religious or philosophical beliefs. One of the things I have been asked is what's a philosophical belief, and somebody has suggested that if you're a Jedi, then that is a philosophical belief. Not sure whether that's the case, but I'm sure this will come out in the wash as we get guidance going forward. It also covers things like people's sex life or sexual orientation. The reason why this data is pulled out is that it gets an extra layer of protection. What you do with it and how you have to look after it is more heavily restricted under GDPR. As I said, ordinary personal data is everything else, which begs the question about financial data. Obviously, you have to look after financial data very carefully, and in view of the additional restrictions on special categories of data, I'm often asked whether or not financial data is ordinary personal data or special categories of personal data. Technically, financial data is ordinary personal data, but you do have to look after it in a particularly secure manner, and if you were to have a data breach relating to it, then it would be regarded as more serious than most categories of ordinary personal data. I think it's helpful to think about potentially therefore there being three categories of personal data. So you have ordinary personal data, which is the sort of lower level of protection, although it still gets quite a lot of protection. You then have financial personal data, and then special categories of personal data have the highest level of protection. So the next thing we are going to have a look at is, so we understand what's covered, what do you do to prepare for 25th of May? So now we've understood the fundamentals of what's covered and the defined terms, what we're going to move on to is to have a look at first steps towards compliance. In my view, you need to carry out an audit of the personal data that you hold. If you don't understand what you've got, then you can't make it compliant. So what we're suggesting to people is that you should carry out a data audit. You should have a look at what's the data you're holding, how are you using it, who are you sharing it with, things like that. The other thing that you will need to do as part of this analysis is understand whether you're using the personal data in a legal way. There are certain defined gateways which allow you to use the personal data. If you can't bring yourself within one of those gateways, then you shouldn't be using the data. We're going to have a look at what those gateways are for both ordinary and special categories of data a little bit later, but it's worth bearing in mind that when you're carrying out your data audits, this is something that you need to think about. The other thing that I would say in relation to those gateways is that they are slightly different to what was available under the Data Protection Act. Just because you could do something under the Data Protection Act with the data does not mean that you'll be able to do it under GDPR. So I would strongly advise that you bring a fresh pair of eyes in terms of what data you are using, how you are using it, and what the legal basis of its use is. The other thing that you need to bear in mind is that if you have more than 250 employees, you need to keep a document of what data you are holding. And Article 30 of the GDPR has a list of things that you need to include within that document. What that document needs to look like is not something that is prescribed by law. You can do it by buying off-the-shelf software. You could also do it simply by putting together an Excel spreadsheet. The Information Commissioner, which is the regulator in the UK, has recently issued some helpful guidance as to what they think should be included on that document, and they're suggesting that in addition to the mandatory fields that are included, it's also helpful to include some additional fields, simply to pull together all of your records in one place to make compliance in general easier. We would definitely advocate that. We think that it probably makes sense if you pull together exactly what it is you're doing, so that if you have to respond to a query by an individual or by the regulator, then you've got at least a link or an idea of the information in one place, which will make life a lot easier.
So Joanne, who would you suggest within a business is responsible for a data audit or for helping out with GDPR compliance in general?
Thanks, Claire. We often get asked this question. I think that GDPR, because it cuts across all aspects of a business, is the responsibility of a business as a whole. And so whilst you can put somebody in charge in terms of leading the project, and I definitely advise that you put a project together to deal with this, it needs to pull on people from all strands of the business. So for example, on the basis that personal data can include HR data, there should be somebody from HR. It could also include customer data, and it could also include supplier data. So as part of your data audit, as I say, you need to understand the legal basis on which you are using the data. On the next slide, you will see that in relation to ordering personal data, the list of lawful purposes, the legal basis on which you can use it. I would actually reorder that list. I would put consent at the bottom. People are very keen on saying that you need consent in order to use ordinary personal data. What I would strongly suggest, and I know a lot of other people suggest it, is that you look at the other gateways first, and then if you cannot bring your use of personal data into those other gateways, then you consider consent. The reason for this is that consent can always be withdrawn. If the individuals withdraw consent, then you have to stop using their personal data. So I would use it at the bottom of this list. The other ones that are worth thinking about, particularly from a business perspective, are legitimate interests. Legitimate interests involves a balancing test. You have to be able to demonstrate that the business has a legitimate interest in using the data, but also that you are not riding roughshod over the privacy rights of the individuals. Then there's necessity for the performance of a contract. Obviously, if you are selling somebody something online, you need their address in order to be able to deliver the item. So taking their address would be necessary for performance of the contract. Obviously, the law requires a certain amount of personal data to be processed. So as an employer, you'll have to make returns to HMRC. This will involve an element of personal data. Vital interest is something that isn't particularly widely used, and it's only in very serious circumstances where essentially you are trying to save the life of someone. And necessary for the performance of a task in a public interest. Again, in a normal business context, that's not something that particularly will rear its head, but it is more relevant in the sort of public sector side of things.
John, we've discussed that businesses should be looking at other legal bases for processing personal data and consent if they can find one, but are there any circumstances where consent should be considered as the best option?
Certainly, consent needs to be considered from a marketing perspective. The ICO is very keen that you engage openly with people who you're going to market to, and very much likes the use of consent in the context of marketing. It's not the only basis on which you can potentially market to people, but it is something that should be very carefully considered. In addition, as you'll see, the list of things that you can use to legitimise your use of special categories of personal data is very narrow, and explicit consent is quite popular in that context. The difficulty that we will have from the point of view of consent in that context is that some guidance that has been issued by the ICO, which is the UK regulator, and also by the Pan-European advice body, is that you should not be using consent in the context of employees. That makes life quite difficult because it's very common both for ordinary and special categories of personal data that people take consent from their employees. The view taken by the regulators is that essentially the relationship between employer and employee is imbalanced, and so you shouldn't be using consent. What that means is that you need to go back and look at your new starter packs and also your employment contracts, and potentially, and you need and revise those, but essentially you need to look at a different lawful purpose in that context. So now what we're going to have a look at are the lawful purposes relating to special categories of personal data. As I said, the use of special categories of personal data is more heavily regulated than ordinary personal data. You have to show one of the lawful purposes we've already talked about, and in addition, you have to show one of these additional lawful purposes to allow you to use the special categories of personal data. You'll see from the list that the idea of consent remains, but now it has to be explicit consent. There are also a narrow list of things, so for example, compliance with obligations relating to employment law, social security law. Vital interests is back again, and again, as I said, it's very restricted in scope. It applies to things like if someone's life is in danger. And then there are certain ones relating to carrying out public obligations, or where it's necessary for the public interest. In addition, there is also one relating to the establishment or exercise of legal claims, which potentially is quite useful. But as you'll see, they are more limited in scope than the ones we've been talking about in the context of ordinary personal data. So moving on to transparency. We've established a lawful basis of using the personal data, so what are your other compliance obligations? One of the key requirements of GDPR is that you are clear and transparent with people about how you are using their personal data. What this means is, from a practical point of view, is that you have to revisit your privacy policies and your fair processing notices. You need to have a look to see whether or not they're communicating the information you need to communicate under GDPR and in a way that is compliant. There is a list in Articles 13 and 14 of GDPR of the information that you have to tell people in order to be compliant. That considers a lot of the information that you would ordinarily tell people now, but there are also additional pieces of information that you need to think about. For example, one of the things that you need to be clear about is how long you are keeping people's personal data for. I've done a lot of these talks around the country, and when I've asked for a show of hands in various different sessions about whether or not anybody currently communicates that level of information, there's only ever been one person that has. So what it does mean is that you need to look again at what you're saying in your privacy policies and to see whether or not you need to include additional information. The challenge with these privacy policies, or with the transparency obligation, is that whilst there is a long list of information you need to communicate, you need to communicate it in a meaningful way. What this means is that you need to look at the length of what it is that you're providing. It needs to be concise. There is a tension between the amount of information you've got to provide and the provision of it in a concise way. What the ICO is keen on is that you think about using layered policies. So, for example, if you are using an online privacy policy, what you could do is have headings which people are able to click and expand and contract to find the information that they're interested in. The thing you need to bear in mind, though, is even if you use a layered policy, the core information needs to be readily available. I was recently at an event at which someone fairly senior from the ICO was speaking, and they were very clear that things being concise is very important. If you are obscuring information by making your privacy policy incredibly long and complicated, then they will not consider that you have been transparent with people about how you are using their personal data. In addition, you also need to think about your audience. It's horses for courses. the information needs to be communicated to the people you're addressing it to in a way that they will understand. This means if you're trying to communicate, for example, something to children, it needs to be written entirely differently than if you're trying to communicate something to maybe a sophisticated business buyer.
So, Joanne, companies should be putting together fair processing notices to cover all the individuals whose personal data they hold. What do you think are the key policies that companies should be putting into place in terms of who their audiences will be?
I think you need to think about your staff, you need to think about your customers, and you need to think about your suppliers. So from a staff point of view, you need to think about what you're telling people as part of the recruitment and selection process. You need to have a privacy information that you give to your staff about how you use it through the employment relationship. You also need to think about, in terms of with your customers, you need to make that freely available in terms of what data you collect and how it will be used. And also with suppliers, if you have any suppliers, or if you're communicating with individuals within corporate suppliers, and you're collecting and using their personal data, you also need to be clear about that. I was talking to a manufacturer recently, quite a large manufacturer, and their plan in relation to their supplier privacy policy was to make it available online along with their customer privacy policy. The other thing to bear in mind, Claire, as well, is if you're looking for guidance in relation to transparency, both the Article 29 Working Party, which is, as I say, the pan-European guidance body, and also the ICO have some very helpful guidance in relation to what you should be putting in your privacy policies and how you should be communicating it. We're now going to move on to data retention. The thing that GDPR requires is that you look at the data you are holding and you need to set a retention period in relation to it. You should not be keeping personal data for any longer than is necessary. One size doesn't fit all. You need to look at your individual data streams and set a retention period in relation to each of those data streams. So, for example, somebody said to me that they were going to set their retention policy at 6 years. 6 years might work for certain uses of personal data, but it won't, for example, work for marketing data. Something that's come out of the ICO guidance in relation to consent in the context of marketing is that it needs to be refreshed every 2 years. So a 6-year period won't work in relation to that. So what you need to do is to think about what personal data you're holding, how you're using it, and how long can you keep it before the purpose for which you're keeping it has been fulfilled. One of the things that factors into that is, do you need to keep it for any future claims? So, for example, if you're a manufacturer and you face industrial disease claims, that will factor into how long you can keep the data for. The other thing is, for example, pension data in relation to employees. We are hearing from a number of people that we're talking to that people tend to contact previous employers at the very end of their career to ask them about pension arrangements, don't really think about it before they get into their 60s. So again, that will potentially impact upon how long you keep things for. As part of data retention, I would strongly advise that you put together a policy and a record of your data retention. One of the things that GDPR requires is that not only do you do the right thing, but you also document your compliance. So this would mean that all of the things we're talking about, you should have some form of documentation to demonstrate your compliance. So we're saying to people that a retention policy is a very good idea. As part of that policy, you also need to think about how data is destroyed. For example, there was a situation where someone had paid to have some records digitised and also for the paper records to be destroyed. The paper records were then given to somebody in the organisation that they'd engaged and asked that they be destroyed. Destruction involved taking the records to a supermarket recycling bin and trying to put them in. Unfortunately, the recycling bin was full, and so the records were left next to it and some were left hanging out. In view of the nature of the data that was on there, it was particularly unfortunate because it included things like NI numbers. And so when this was discovered, a complaint was made to the ICO. The destruction of the data was not handled in a secure or compliant way, and so the ICO was very unhappy and action was taken. So as part of data retention, you also need to think about data destruction. So
does the ICO have any guidance that businesses can have a look at that talks about retention periods?
The ICO has very helpfully published some of its retention periods online, particularly in relation to how it's dealing with its employee data. And so if you search for that term in terms of what the ICO retention periods are, you will find some quite useful time periods that they are adopting, which you could consider as to whether or not they're right for your business. Moving on to contracts, a lot of people will have arrangements where they share data under a contract. We're going to have a look at where you are sharing data with a data processor. I mentioned that there is a term processing in the context of how you collect and use data. There is also some confusion because there's a very similar term used in the context of contracts. If you are engaging somebody to access personal data for you or to carry out a service in which they may incidentally access personal data, then they will be your data processor, and this is something different to the concept of processing personal data. So a data processor might be a cloud provider. They might be somebody who provides IT support. They might be somebody who does fulfillment in relation to if you're doing, mail sort of catalogues or sort of mail advertisements. If they fulfill if they're a mailing house fulfilling that, then they will also be processing your personal data because they'll see the name and address details. What you need to do from a GDPR point of view is understand what arrangements you have in place. You need to make sure that they are all subject to written contracts, and in relation to your processes, there is a defined list of things that you need to include in the contract with them. Now, there were provisions under the Data Protection Act that required your processes to meet certain obligations, but they were very focused on security. Under GDPR, the mandatory obligations are focused more broadly on GDPR compliance. So what you need to do is you need to find any contracts that you currently have with data processors and have a look to see whether or not they need to be amended. It's possible that if you've gone over and above what's required under the Data Protection Act, that they are GDPR compliant. I would be surprised if everything is included in there, so I think you should check what GDPR requires to go into your contracts and make sure that they are compliant. What that will mean is that you will need to potentially vary existing contracts. Certainly with new contracts, you need to make sure that the GDPR compliant clauses are in there. We are getting very close to May, and so it may well be that your suppliers or your processors are happy to accept GDPR compliant clauses now. If not, then you could go down the route of having two-tier clauses. So, for example, you have a clause that will apply until the 25th of May, which is Data Protection Act compliant, and then you have another clause which takes effect after the 25th of May or 25th of May onwards, which deals with GDPR compliant clauses. But this is something you need to think about. The other thing you need to think about in the context of contracts is data protection due diligence. You need to be sure that you have got a competent data processor handling your personal data. So if you haven't carried out due diligence in relation to your processes from a data protection point of view, now is the point to look at existing arrangements. You might want to send out a GDPR readiness questionnaire, and with new processes, you should build in data protection due diligence as part of your procurement process. Moving on. The next key topic we're going to have a look at is training and the appointment of a data protection officer. Any of your staff who handle personal data should be trained in relation to the requirements of GDPR and what their role entails. Obviously, the training needs to be tailored for the particular role. Those who handle more personal data need more intensive training, but essentially everyone needs to understand about the need for handling personal data in a compliant, secure and confidential way. Training is quite important. It may be seen as a bit of a cherry on the cake, but in actual fact, carrying out the right training to the right people can make the difference between being fined and not fined. If you have a data breach issue, one of the things that the ICO will be very interested in is whether the staff concerned, if it relates to a staff error, whether or not they've been trained in terms of how to handle that data. The other thing that you need to think about is how you're going to evidence that training and refreshing the training. You need to keep a record. As I said earlier, one of the important things from a GDPR point of view is documentation. You also need to refresh the training. Just because you carried out GDPR training once doesn't mean that you can then just leave it. It's not sort of done and dusted. You do need to refresh it on a regular basis. You also need to consider whether or not to appoint a data protection officer or DPO. Another myth that surrounds GDPR is that all businesses will require a data protection officer. That is not the case. In the case of a private sector business, then there are essentially two tests which decide whether or not you need a data protection officer. You need to have a look at the core activities of the business and see whether or not it involves regular and systematic monitoring of individuals on a large scale. If that's the case, you need a data protection officer. Equally, if you are going to be using special categories of data on a large scale, then again, you need a data protection officer. If you don't fall into those categories in the private sector, then you don't strictly need a data protection officer. Sometimes I'm asked whether or not you should appoint one anyway. I would be wary of appointing someone to the formal role of a data protection officer if you don't need one, because if they don't comply in full with the obligations of a data protection officer, then you can be fined for non-compliance. What I would suggest instead is that if you don't need a data protection officer, then you appoint somebody who is the focus of data protection compliance, but you don't call them a data protection officer. Moving on to a new concept under GDPR is the compulsory carrying out of privacy impact assessments or data protection impact assessments. It's already suggested by the UK regulator that if you are carrying out any high risk processing, that you should voluntarily carry out a risk assessment done via a PIA or DPIA as they're called. Under GDPR, in certain circumstances, it will be compulsory to carry out a privacy impact assessment or data protection impact assessment. What they are is essentially looking at what you are intending to do with the personal data and looking at the risks involved. So it is a risk assessment and it should be built into your project initiation process. You have to carry out a PIA or DPIA where you are essentially taking on board new technologies or doing something, the new service or product or process will impact on individuals in a manner that gives a high risk to their rights and freedoms. So if you're going to launch a new service or if you're going to carry out an internal process in a different way that will potentially have a high will impact upon people in a high risk way, then you need to carry out a DPIA or a PIA. There is some guidance that's issued by the Article 29 Working Party, which is a pan-European advice body, in terms of what you need to include and what you need to do. And certainly the ICO has some guidance under the Data Protection Act that we're assuming will be updated shortly in relation to them. And it is quite useful. What I would suggest is that you put together a template of what your DPIA or PIA will look like for your business, so it uses terminology that's meaningful in your business, but also hits the requirements that are in that guidance and in the GDPR.
So once a business has carried out a DPIA, is that it then, or are there any other considerations?
No, I think what you need to bear in mind is that a DPIA should be regarded as circular, and you'll see from the slide. Essentially, once it's been done, it can't be put away in a cupboard and forgotten about. It needs to be a living document. So if the risk profile changes at any point, then you need to redo the DPIA. Also, as a matter of good practice, you should review it on a periodic basis, around every 2 years, to make sure that even if you don't think the risk profile has changed, to make sure that in actual fact it hasn't. Moving on to data subject rights. The rights of individuals under GDPR have been expanded, and it is an area that is getting quite a bit of press coverage. There are some familiar rights under GDPR, so for example subject access requests. These rights exist under the Data Protection Act now, and we generally see that people ask for a right to access their personal data in the context of, say, a dispute. So, for example, if there is a concern or a complaint the customer has, or if there is potential disciplinary or action being taken as part of an employment process, then often subject access requests are raised. A subject access request requires you to provide personal data to the individual in terms of to explain to them what it is that you're doing and to provide that data. And at the moment you can charge a £10 fee and you have 40 days in which to respond to the individual. Under GDPR you won't be able to charge a fee and you will have a calendar month in which to respond to the individual. You'll also have to provide additional information. So subject access requests, which can be quite painful now, will be more difficult under GDPR, and you do need to be prepared for how you're going to deal with them. And I'd strongly advise that you think about what your process and procedure around subject access is to make sure that you will be able to meet the shorter deadline under GDPR. The right that is getting a lot of press coverage is the right to be forgotten. There is a lot of talk about this and a lot of misconceptions surrounding it. The press are trumpeting it as a right of individuals to be able to ask for their personal data to be erased in any circumstances. And certainly we have seen it raised in circumstances where it doesn't really apply. It has limited scope. So, for example, if you are processing personal data on the basis of an individual's consent, then that's one situation where the right to be forgotten applies. As I said earlier, I am not keen on consent on the basis that consent can always be withdrawn. So if they withdraw consent, you can't continue to process the data and they can also ask for it to be erased. Similarly, if the data is out of date and you are using it, or you're using it in a manner which you shouldn't be using it from a legal point of view, then they can exercise their right to be forgotten. I think it's useful as a business to understand in full the scope of the right to be forgotten, because we think that this will be an area where there will be people that will be misunderstanding their rights and will be approaching you purporting to exercise their right to be forgotten, and it won't necessarily have any basis under GDPR. What you need to think about in the context of right to be forgotten is that you need to make sure that if you are asked by someone for them to exercise their right to be forgotten, is that you don't delete data that you don't need to delete. So, for example, you wouldn't want to be deleting things from your database if you need it for another purpose. Equally, you need to be set up so that you can actually action a right to be forgotten if it genuinely has a basis. So I think it is something that needs some quite careful thought. Some people are sort of saying that the right to be forgotten means that they can approach businesses and ask them to forget about the fact that they owe them money. This is most definitely not the case, and I think the key to the right to be forgotten is understanding its scope and having somebody who is the focus of activity in relation to this, so that if you get a request, it goes to somebody who knows how to handle it. The other thing that you need to think about quite carefully is data breach. Under GDPR, data breach in certain circumstances, you will have to compulsorily notify it to the regulator and potentially to the individuals concerned as well. There are two different tests in relation to data breach. You will have to notify it to the regulator, i.e. the ICO, within 72 hours unless you can show that the data breach is unlikely to result in a risk to the rights and freedoms of the individuals. There is a different test applying to individuals. You have to notify to the individuals where there is a high risk to their rights and freedoms. So as you'll appreciate, the two slightly different tests means that it's more likely that you're going to have to notify the regulator than notify the individuals concerned. As I said, if you are going to have to notify the regulator, you need to notify within 72 hours. What that means is that you need to have a procedure and a process and a policy set up as to exactly what you will do in the event of a data breach, because you need to understand what's happened, what the effect of it is, and whether it's notifiable in a very, very short timescale. There has been some guidance that's been issued in relation to what a data breach is under the Article 29 by the Article 29 Working Party. I would advise that you have a look at it because the scope of data breach is much wider than you might think. And so, for example, it can cover temporary lack of availability of a system if that will impact in a serious way on people's personal data or their rights. Equally, if you have lost a decryption key for some data that you've encrypted and you have no backup, again, that can comprise a data breach. So I'd strongly advise that it's worth having a look at that guidance to understand the full scope of data breach.
Having a look at the slide, it looks like there are some situations where a business might not necessarily need to notify the individuals about a data breach. What would those situations be?
Yeah, you're right, Claire. If there are technological and organisational protection in place, you don't have to notify the individuals. So, for example, if you lose some data and maybe it's on a laptop or it's on a memory stick and that is fully encrypted and they can't actually get to the data, then the argument is that there is obviously technological protection, which means that you don't have to notify it to the individuals concerned. Equally, if you've taken action to eliminate the risk, then you don't have to notify it to the individuals. So, for example, if Claire and I are travelling on a train and I leave my laptop on a train, then Claire, if she sees it and brings it to me immediately, then because nobody could actually have accessed it, then we would have taken action to have eliminated the high risk. Also, my laptop is encrypted, so we'd have got a double whammy there. The third one, where you don't have to notify the individuals, is where it would involve disproportionate effort. I would strongly advise that you don't go down this route, because if you are arguing that it would involve disproportionate effort to notify the individuals concerned, you have to communicate with them in a different way. So, for example, taking out a prominent statement or advertisement in the press to be able to tell them that there is a risk to their personal data. Obviously, communication via email is a lot more private than announcing to the world that you've had a data breach. So I would be very, very wary of using that third exemption. So what's going to happen if you don't comply with GDPR? Currently, if you are in breach of the Data Protection Act, then the maximum fine that the ICO can levy against you is $500,000, which seems like a large sum of money. But when you consider the GDPR, the fines are much, much bigger. You'll see from the slide that there is a two-tier system. Certain breaches, then the maximum fine will be up to 10 million or 2% of global annual turnover, and for more serious breaches, then it will be up to 20 million euros or 4% of worldwide annual turnover. This is obviously particularly painful for group companies in terms of looking at the group as a whole and also looking at worldwide activities. So these fees are potentially very, very serious. One thing I would say, however, and I'm taking some comfort from it, is that when I was recently at an event with a representative of the ICO, they were at pains to point out to the audience that they will remain a fair and proportionate regulator going forward. So fingers crossed, a pragmatic and fair approach will still be taken by the ICO in relation to fining going forward. One of the other things that you need to bear in mind in relation to what might happen for a breach of GDPR is that there is also the possibility of individuals suing you in the civil courts and making claims in that way. And certainly we understand that there are group actions which are currently in the offing, and so it is something that you do need to be quite careful about, on the basis that in addition to being fined, you could face having to pay out damages to any individuals affected. So in summary, what do you need to do to become GDPR compliant? These are the headline issues. There is a lot of complication to GDPR, but this is what we would say as being the things that you needed to think about in order to become GDPR compliant. You need to carry out a data audit. You need to understand what data you have and how you are using it. If you're a business of over 250 employees, you need to document that in a mandatory record. You need to have a look at the basis that you're using the data for in terms of, is it legal? If you are using consent, then you need to review your consent. GDPR consent is different to data protection consent, and that's one of the things that you need to think about quite carefully. Pre-ticked boxes are not consent from a GDPR point of view. There has to be active consent given. You need to look at how transparent you are with people about how you are using their personal data, so you need to revisit your privacy policies. You need to look at how long you're keeping data for. You need to set a retention policy. You also need to think about whether or not you're keeping too much data, hand in hand with the data retention policy, is that you need to minimise the amount of data that you keep. On the basis there is a requirement that you minimise the amount of data. You need to review your contracts. You need to make sure you have contracts in relation to any arrangements with processors. You need to make sure they've got the mandatory clauses in. You need to carry out staff training. As I said, it's horses for courses. Anyone that handles a lot of personal data needs to have much more training than someone who just occasionally gets access to it. You need to think about whether or not to appoint a data protection officer. You need to set a number of policies and procedures in relation to how to deal with the enhanced rights of individuals. What will you do to deal with a subject access request? What will you do in terms of the right to be forgotten? There are additional rights of individuals as well, which you need to think about, which is the ability to rectify data and the ability to request data is given to them in a format to enable them to make it portable in certain circumstances. So that's something you need to understand and prepare for. And finally, you need to think very carefully about data breach. You need to prepare for data breach, because if you're going to have to notify within 72 hours to the regulator, you need to know what you're doing. So that's GDPR in a nutshell. It's very much a quick canter through, but hopefully it's been useful in terms of pointing you on key topics in the right direction.